Mr. Eagle? I've got a couple.
Yes, sir.
I've got a couple of pleas to do, and since you have offered to let all the attorneys here go before you, you need to step away, then I won't call your case until I see you back, if there's things you need to take care of. Did you hear me okay?
No, sir, I didn't. You cut out. I'm not.
All right, sorry about that. I said since you're appearing Zoom and you offered to allow the court to take care of the attorneys that are here, you need to step away and take care of some business. I will not call your case until I see you again.
All right. Well, it'll take about 30 seconds, Judge, whenever you're ready.
Okay. All right. Well, I'm going to do these couple pleas with Mr. Gimbel. And
okay. Great. Thank you.
You're welcome. All right, Mr. Murph. I'm sorry. That's the next one. Mr. Williams, raise your right hand. You are Xavier Tayshaun Williams, is that correct?
Yes, sir.
And Mr. Williams, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, let me put your hand down. Make sure you speak up loud enough that I can hear you and that my court reporter can hear you, okay? All right, Mr. Williams, are you a United States citizen?
Yes, sir.
And do you read, write, and speak the English language?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Brent Gimbel. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
You understand everything that you have reviewed, read, and signed?
Yes, sir.
Mr. Gimbel, do you believe Mr. Williams to be competent today?
I believe he is, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, I have, Your Honor.
And you've also explained to him the advantages and disadvantages of a deferred adjudication. Is that correct?
Yes, Your Honor.
Mr. Williams, you are charged with, well, pursuant to your plea agreement, the range of punishment for a Class B misdemeanor offense of possession of marijuana is confinement in the county jail for a period not to exceed 6 months or 180 days, and or a fine not to exceed $2,000. Do you understand that range of punishment?
Yes, sir.
I see here that the proposed plea agreement is that Mr. Williams will plead guilty to the Class B misdemeanor offense of possession of marijuana. The state's recommending that it's a finding of guilt be deferred on that lesser included charge. That punishment be assessed at 18 months community supervision with a fine of $500. In addition, you would have $270 court costs and reimbursement fees of $535. Is that your understanding of the plea agreement, Mr. Gimbel?
Yes, it is, Your Honor.
Yours as well, Mr. Williams?
Yes, sir.
All right, Mr. Williams, then let me ask you at this time, how do you plead to Class B misdemeanor offense, possession of marijuana alleged to have occurred on February 3rd, 2020? And Mr. Williams, are you pleading guilty because in fact you are guilty of committing that offense?
Yes, sir.
Has anyone threatened you, forced you, or made you plead guilty?
No, sir.
All right, the court will accept Mr. Williams' plea of guilt. Mr. Gimbel, is there any objection to the admission of States 1, the stipulation of evidence in this case?
No objection.
Court admits States Exhibit 1, takes judicial notice of Mr. Williams' judicial confession. Anything further from the state?
No, Your Honor, we would rest and close.
Anything further from the defense?
Nothing from defense.
All right, Mr. Williams, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement. The court hereby defers a finding of guilt, places you on community supervision for a period of 18 months, assesses a $500 fine, court costs of $270, and orders you to reimburse Vincent County in the amount of $535. And Mr. Gimbel, do you have the conditions of community supervision?
I believe that was provided to Mr. Williams.
I need to get those. Mr. Williams, you've got the conditions of community supervision with your attorney, Mr. Gimbel? You've read over those? You understand them? You know what's required of you? Violate a single one of those and the state files a motion to adjudicate your guilt. If they bring you back before the court, you're not going to get a trial on whether or not you possess marijuana. There's going to be a hearing on whether or not you violated the terms and conditions of your community supervision. You understand, if you don't take those serious, you could be facing a serious confinement in the county jail up to 180 days. You understand that?
Yes, sir.
Right. You're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of your sentence. I'm going to have you step up here to be fingerprinted with my bailiff, after which you're to report to the probation department through this door. Come on up, Mr. Williams. CR 2060 State versus Colton Murph. I'll give this to you. All right, Mr. Murph, please raise your right hand, sir. I'm going to place you on your oath. Mr. Murph, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand up. Mr. Murph, are you a United States citizen?
Yes, sir.
And do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
ADHD.
Are you currently on medication for ADHD? Do you feel like the fact that you're not on medication for ADHD in any way inhibits or prohibits your ability to understand the proceedings against you today? In this case, you're represented by your attorney, Mr. Brent Gamble. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had sufficient time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
Anything about this plea that you do not understand?
Yes, sir.
Mr. Gamble, do you believe your client to be competent?
I believe he is, Your Honor.
And you have explained to him his legal and constitutional rights?
Yes, I have.
Mr. Murph, you are charged by indictment with the third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams. It carries a range of punishment of confinement in TDC for not less than 2 years nor more than 10 years, and also carries a fine not to exceed $10,000. Any plea agreement that you negotiate with the state or any sentence handed down by the court would have to fit within that range. Do you understand that? Yes, sir. It appears to me that you want to enter into a plea agreement with the state in which you would plead guilty to that offense, and the state's recommending that you be convicted of that offense, that your sentence be assessed at 10 years confinement in TDC, but that sentence be suspended and you be placed on community supervision for a period of 3 years with a $2,500 fine and $180 restitution. In addition to that, you would also have $860 in reimbursement fees that you owe to Van Zandt County. Is that your understanding of the plea agreement, sir? Yours as well, Mr. Kimball?
It is, Your Honor.
All right, Mr. Murph, then let me ask you, how do you plead to the third-degree felony offense of possession of a controlled substance?
Yes, sir.
And Mr. Murph, are you pleading guilty because in fact you are guilty?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty to that offense?
No.
Court will accept Mr. Murph's plea of guilt at this time. Mr. Gimbel, is there any objection to the admission of State's Exhibit 1?
No objection, Your Honor.
Court admits State's Exhibit 1, stipulation of evidence, and takes judicial notice of Mr. Murph's judicial confession. Anything further from the state?
No, Your Honor, we rest and close.
Thank you, Ms. Heisel. Anything else from the defense?
Nothing from defense, Judge.
All right, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in your case. The court hereby convicts you of the third-degree felony offense of possession of a controlled substance. The court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspends that sentence, places you on community supervision for a period of 3 years, assesses a $2,500 fine, orders you to pay $180 restitution. Court also orders you to pay court costs of $290 and $860 in reimbursement fees. All right, Mr. Murph, you've gone over your conditions of community supervision, is that right?
Yes, sir.
And you know what's expected of you?
Yes, sir.
And you know what's required of you?
Yes, sir.
And you know what happens if you violate your community supervision, right?
Yes, sir.
How long would you be looking at up in prison if you violate your community supervision?
10 years.
Up to 10 years. It's pretty serious. You ever been to prison?
Yes, sir.
Do you want to start now?
Yeah.
All right. All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward with my bailiff to be fingerprinted, after which report to probation department through this door. Thank you, sir.
That's all I have. I'd be excused.
Yes, sir. Thank you, Mr. Greenwald. All right, and based on the brief announcement that I heard from you before, there's no agreement on this case, and you're looking for a setting where you can put on evidence and make an argument?
I guess so, Judge. This is a situation, Judge, he's placed on probation August 5th of 2010, 5 years confinement probation for 5 years. Their probation was extended for 5 years to August 4th of 2020. Their probation has expired. However, the warrant and the motion to revoke was filed on August 4th of 2020. And it's a situation, Judge, where we're talking about money and some other things, and also he had a stroke, he's had a heart attack, and
Well, let's do this before we get into evidentiary issues. Have you spoken with the state about this and y'all tried to reach an agreement?
what kind of agreement reach, Judge? I mean, probation.
Oh, I don't,
I mean, I'm just saying it can't be extended or anything, you know?
no, but as a former DA, I know there's all kinds of agreements that can be reached, but
Well, I can talk with him, but I just knew that it could not be extended to probation, you know?
okay.
I can talk with him, you know?
Well, let's do this then. Really, the only thing that I can do is set you for a contested hearing, and I can do that. That's pretty easy. I'll set you for contested hearing on the state's motion to revoke or adjudicate. We'll set that on October 1st.
That'd be fine, you know?
October 1st at 9 a.m. and then we can take up evidentiary issues on that day. That day is reserved for evidentiary cases, unlike our docket calls and our bigger dockets today, where if I took a testimony, we would never get through. So it'll be a much smaller docket that day, and I'll listen to your evidence and your legal arguments on that day. The court will issue a ruling most likely that day.
Yes, on August 1st.
Yeah, October 1st. If you'll get a notice of setting out of there, Mr. Robertson.
Oh, yes, Your Honor.
And then go ahead and fill that out with its cause number, and then put that date on there, October 1st at 9 a.m.
Yes, Your Honor.
And then leave me the white one, and he gets the yellow.
Yes, Your Honor.